Hey, what's up, perps? We got another bill. Unfortunately, we're never going to run out of them at this rate. Nope. But this one's another big giant pile of uncool. So let's get into it. This is the Virginia plan to stop gun violence. All right, got the share. All right, let's roll over here. And let's start this dumpster fire. Okay, let's see. So this bill came in. This was introduced on 4/15/2021. This was introduced by Mr. Tim Kaine. And I believe that's Mark Warner who signed on to this bill. I haven't looked at the co-sponsors on this bill for a little bit, so I don't know whether it is increased with co-sponsors or anything like that. More than likely, with the way Democrats are going these days, it more than likely has. So let's get into this. This one is going to be pretty painful. Well, all of these are. Okay, so this is the Virginia Plan to Reduce Gun Violence Act. To reform federal firearms laws and for other purposes. As always, there are plenty of other purposes with these bills. So let's get down into this. You see all the stuff in the table of contents up here. Anytime you see table of contents at the start of one of these bills, you know it's going to be exceptionally diluted and insane. And here we go. So this edits firearms transfers. We get over here to section 922, where's my 922? Here we go. Section 922, unlawful acts. And let's slide down so as usual you guys can see where this is actually added into the code. Remember, this is existing US law that we're flipping through right here. So the first thing is, actually I think that in red comes in at another time because this thing edits it a couple times. So they add in this paragraph AA down here. Is this where I'm at? Nope, that was another edit. Yeah, there's plenty of edits in this thing. It's crazy, to say the least. Because they are trying to deal with so much in this act. It's just mind numbing. All right, section AA. This is the part they're talking about over here. So this is going after person to person transfers. Yes, under a bill like this, you could be fined and thrown in jail for a person to person transfer. Okay, it shall be unlawful for any person who is not a licensed importer, licensed manufacturer, licensed dealer to transfer a firearm to another person who is not so licensed unless a licensed importer, manufacturer, dealer has first taken possession of the firearm for the purpose of complying with subsection T. Subsection T is a background check. So this is universal background checks. No more person-to-person sales or transfers. I keep wanting to say sales, but it's a transfer. That means giving someone a gun, with limited exceptions, loaning someone a gun. I mean, all that is covered in this. Upon taking possession of a firearm under subparagraph A, the licensee shall comply with all requirements in this chapter. If a transfer for the firearm doesn't go through for some reason, then the FFL basically can transfer that gun right back to its owner. And as usual, kids, the government gives themselves carve outs because laws don't apply to our rulers. Shall not apply to, and we've seen this before, it's just getting old. A law enforcement agency, law enforcement officer, armed private security professionals, member of the armed forces, and that's while they are acting in their profession, not just an armed or officer or whoever in the armed forces. Um, to the extent the officer, professional, or member is acting within the course and scope of employment and official duties, that is the key there, official duties, which you know good and damn well these people would go over there and or in law enforcement's case, they'd go to a FFL, flash a badge, and be like, hey, I'm a cop, and they can just transfer it out. Let's see where we're at. So we're in the shall not apply to. A transfer that is a loan or bona fide gift between spouses, domestic partners, between parents and their children, including step parents and their stepchildren, between siblings, between aunts, uncles, and their nieces and nephews, or between grandparents and their grandchildren. So those are the people you could give a firearm to. Anybody not explicitly on that list, if you decided you wanted to be a good dude and buy your buddy a gun, yeah, you're going to prison. Yeah, have fun with that. Shall not apply to a transfer to a executor, administrator, trustee, or personal representative of an estate or a trust that occurs by operation of law upon death of another person. Now, this is absolutely retarded, but okay. What they're basically saying is here, upon death, your firearms are going, like if I died and I was single, my firearms are going to go to a lawyer, or they're going to be confiscated by the government, probably. I couldn't just simply leave those firearms to a friend, a cousin, any number of different people that and loved ones that you have in your life, unless they're on their specific list. What you do with your own personal property is the government's business, apparently. This shall not apply to a temporary transfer that is necessary to prevent imminent death or great bodily harm if the possession by the transferee lasts only as long as immediately necessary to prevent the imminent death or great bodily harm, including the harm of domestic violence, a dating partner violence, sexual assault, stalking, and domestic abuse. That's not very well lined out. What they're talking about is you taking a gun from somebody so you can stop them from using a gun in these acts. They definitely would have issues if you had a friend who was worried about something like this happening and you loaned them a temporary transfer. Yeah, that would probably still put you in prison. Shall not apply to a transfer that is approved by the Attorney General underneath subsection Internal Revenue Code of 86. Because they get to do whatever, because reasons, right? A temporary transfer if the transferor has no reason to believe that the transferee will use or intends to use the firearm in a crime or prohibited from possessing firearms under federal or state law, and the transfer takes place and the transferee's possession of the firearm is exclusively at a shooting range or in a shooting gallery or other area designated for the purpose of target shooting. So I could loan a gun to my friend at the range and he could shoot my gun. That is a transfer. If I If I'm standing right there with him and I hand him my gun and tell him to shoot it, I have just transferred a firearm to somebody. So I could do that at a range, apparently. But what if, like where I'm at, I can shoot on my own property? It's not an area designated for shooting. Not what they're calling designated, anyway. So if I'm out shooting with my buddy and I shoot his gun, he shoots my gun, then we're committing felonies. Let's see. While reasonably necessary for the purpose of hunting, trapping, or fishing, if the transferor has no reason to believe that the transferee intends to use the firearm in a place where it is illegal, and has no reason to believe that the transferee or has reason to believe the transferee will comply with all licenses, permits, requirements, and all that. So if I loan a gun to a buddy of mine, which I've done plenty of times for them to go hunting, what happens if they missed getting some sort of license? That would make me responsible for this. While in the presence of the transferor. Okay, maybe that would cover. I don't know. This stuff's so convoluted; it's just insane. Notwithstanding any other provision of this chapter, the Attorney General may implement this subsection or this subsection with regulations. I'm getting to where I can't talk again. Regulations promulgated under this paragraph may not include any provision requiring licensed facilities to transfer in accordance with paragraph 1. So, in other words, they can't force an FFL to do transfers. An FFL could tell you to get bent, they're not doing the transfer. Regulations promulgated under this paragraph may not include any provision requiring persons not licensed under this chapter to keep records of background checks or firearms transfers. So, hey, they're throwing you a little bit of a bone here. You don't have to keep a record whenever you transfer a gun to somebody through an FFL because the FFL is going to have that information. Okay. Regulations promulgated under this paragraph may not include any provision placing a cap on the fee licenses or licensees may charge to facilitate transfers in accordance with this paragraph. Which is good. They're not trying to limit what a business can charge to do firearms transfers, and they're fixing to throw a hell of a lot of business their way if something like this ever went through. That's mighty nice of them. It shall be unlawful for a licensed importer, licensed manufacturer, licensed dealer to transfer possession of or title to a firearm to another person who is not so licensed unless the importer, manufacturer, dealer has provided such other person with a notice of the prohibition under paragraph 1, and such other person has certified that the other person has been provided with this notice. So in other words, they're going to have to give you, even when you go through a background check, they're going to have to give you some sort of pamphlet or informational thing that says, I have been informed that it is illegal for me to do a person-to-person transfer, and it is illegal for me to loan my firearm to somebody except in very specific circumstances and all this other just absolute crap. And then I have to certify on that statement that I have received such information. Then I can get a firearm transferred to me. You guys tired of this shit yet? And again, here we go. Let's see, except as provided, shall be unlawful for a person not a licensed importer, licensed manufacturer to purchase more than one. I haven't hit that yet. Nope. Shh. I haven't got there yet. Quit paying attention to that. We still got a ways to go in this absolute damn dumpster fire. Oh, let's see. So this is all the stuff we went through: transfer, loan, bona fide gift, blah blah blah. Don't buy your girlfriend a gun because they're gonna put you in prison. Don't be a buddy. Buy your buddy a gun. You're gonna go to prison. Which they would do that shit now. They're just putting more teeth into it. Let's see. That's where you could transfer the gun. This was the Internal Revenue Code 86. Yada, yada, yada. Okay. Effective date. This shall take effect within 180 days of this thing being passed. Now they go to handgun sales. And that's where, hold on, I know where I was right near it. It's up here. Okay, so yeah, it's right here. So this is where they come back in. They make another edit to 922. Limitation on multiple handgun purchases. Because reasons. Except as provided in paragraph 2, it shall be unlawful for any person who is not a licensed importer, licensed manufacturer, licensed dealer to purchase more than one handgun in a 30-day period. So if you buy a handgun one day and you're at another store within the next few days and decide that you really like that handgun too, well, no love for you because you already spent your handgun allotment for the month. If you and your wife or whoever decided that you guys wanted to update your carry gear and you were out and you saw two really nice guns and you decided, hey, me and my wife been looking for those guns. You can't just pick them up. You would have to basically drive, go get her, have her meet you, and have to do two separate transfers because reasons. Okay. 2. Paragraph 1 shall not apply to individuals with a certificate issued by law enforcement agency of the state in which the individual resides, certifying the individual has passed an enhanced background check. Oh, okay. An enhanced background check. I'm still kind of gnawing on that. So let's see. Let's come back over here and let's read a little bit more about this. B shall not apply to law enforcement agency, law enforcement officer, member of the armed forces. Again, when they're acting within the scope of employment and official duties. Shall not apply to state or local corrections facilities, a private security company licensed by the state or local unit of the government. The purchase of the handgun that is an antique firearm, listed as a curio or a relic. Now, generally, a lot of people buying curios and relics who are running in that world, a lot of them have FFLs already. I can't remember what number that particular FFL is. It's not very expensive. I think it's like $25 a year or some shit. But it allows people to buy curios and relics. Gee, thank you. Like no one has ever killed with firearms before very recent times, or handguns, I should say. So, buy all the relics you want. They never killed anybody until these idiots figure out that 1911s, in a lot of cases, and a lot of other older semi-automatic handguns are actually antiques, and then they'll change that shit quick. Effective date, this is again 180 days. This takes effect. All right. Now we go to, guess what, kids? Everybody's favorite subject, extreme risk protection orders. Yep, extreme risk protection orders. Take your shit. You don't even have to be convicted of anything. You don't even have to be charged with anything. You don't have to be at the hearing. You don't get to defend yourself. Yep. And as we will see down here in this chapter, there's a lot of really wacky shit in here. Your privacy doesn't mean shit. Illegal searches, nope, don't mean anything. It's going to get fun. All right, eligibility. This is about the grants, because the federal government wants to give states money to have the states do the legwork to take your freedom and your constitutional rights. A state or Indian tribe that enacts legislation described in 203, which is what we're looking at, with respect to the Attorney General, determines that the legislation described in Clause I complies with the requirements of Section 203, and that certifies to the Attorney General that the state or Indian tribe shall use grant under Section 202 for the purposes described in Section 202B, and allocate not less than 25% of the amount received under this grant for training of law enforcement officers. So, let's dig a little bit deeper into this giant hole of stupidity. Let's see. Or a unit of local government or other public or private entity that is located in a state or territory under the jurisdiction of an Indian tribe that meets requirements described in clauses I and II of subparagraph A, certifies to the Attorney General that the unit of local government or entity shall use a grant under Section 202 for the purposes described in 202B. So this could be a town or a city or a county getting these grant funds. Allocate not less than 25% of the amount received under the grant for training of law enforcement officers. Because they have to train officers how to completely strip you of your constitutional rights with no due process whatsoever. Extreme risk protection order. The term extreme risk protection order means a written order or warrant issued by a state or tribal court or signed by a magistrate or other comparable judicial officer, the primary purpose of which is to reduce the risk of firearms-related death or injury by doing one or more of the following. Prohibiting a named individual from having under their custody or control of that individual owning, purchasing, possessing, or receiving a firearm. These will make you a prohibited possessor, which means you can't purchase, you can't transport, you can't, nothing. No firearms, gone. See ya, bye. Having a firearm removed or requiring the surrender of firearms from a named individual. So yeah, they will send you a letter and tell you need to surrender your shit, or the cops just show up and take your shit. That will be the first time that you hear about what is going on. Firearm term, firearm, giving the meaning under Section 921 of the 18 United States Code. Remember, that's basically most of or a lot of the definitions for what firearms are and what types of firearms there are. Indian tribe, they define that. Law enforcement officer, of course, they go through and they define law enforcement officer. Means a public servant authorized, and that kills public servant. Public servant. How is this public servant just going to strip me of my private property and my rights? That didn't seem like a servant to me. Um, let's see, authorized by state, local, tribal, local government, all that. To engage in or supervise the prevention. Now, get this. All right. To engage in or supervise the prevention, detection, investigation, or prosecution of an offense. Detection and investigation sounds like somebody sitting there picking through my social media and picking out things that I say, and I have probably said a lot, that could be kind of inflammatory, to say the least, and then they could come take my shit. Or supervise sentence criminal offenders. That would be like a probation officer. Petitioner. The term petitioner means an individual authorized under state or tribal law to petition for an extreme risk protection order. The term state means, yes, they actually get into that, a state, District of Columbia, Commonwealth of Puerto Rico, and any other territory or possession of the United States. Unit of local government. Unit of local government has a meaning given in the term Section 901 of the Omnibus Crime Control Bill, Safe Streets Act of 68, Extreme Risk Protection Grant Program. In general, the Director of the Office of Community-Oriented Policing Services of the Department of Justice shall establish a program under which the amounts made available to carry out this section, the Director may make grants to eligible entities to assist in carrying out the provisions of the legislation described in 203, which is your red flags. Use of funds. Funds awarded under this section may be used by an applicant to enhance the capacity of law enforcement agencies and the courts of a state, unit of local government, or Indian tribe by providing personnel, training, technical assistance, data collection. Again, that sounds like someone monitoring my activities. And other resources to carry out legislation described in 203, the red flags. These funds can be used to train judges, court personnel, law enforcement officers to more accurately identify individuals whose access to firearms possesses a danger of causing harm to themselves and others by increasing the risk of firearm suicide or interpersonal violence. So again, to more accurately identify individuals, that sounds like some monitoring, and we'll get into it in a little bit in this bill. Yes, law enforcement can put red flag papers on you. Doesn't have to be anybody that you are intimately involved with. Now, understand, and I gotta hit this right there, just because it's about that time. All right. Understand, in every state in the United States, there are ways for law enforcement or family members or friends to have you involuntarily committed to get you treatment for many, many different situations, thus removing you from the equation, so that you wouldn't be out on the street and have many, many other dangerous or deadly weapons at your disposal. Red flag laws focusing on taking your guns before you are convicted of anything are a whole nother story. In other words, if this situation could be solved already legally without depriving someone of their constitutional rights, why are we looking to deprive people of their constitutional rights? Because this isn't about firearms and protecting people. This is about them taking firearms because they just don't like the fact that Americans can be armed. It's got nothing to do with public safety. Alright, now after that little rant, where were we at? Use of funds, train judges. Okay, develop and implement law enforcement and court protocols, forms, and orders so that law enforcement agencies and the courts may carry out provisions of the legislation described in Section 203 in a safe and effective manner, including through the removal and storage of firearms pursuant to extreme risk protection orders under the legislation. Again, what funds can be used for. Funds can be used. Raise public awareness and an understanding of the legislation described in 203 so that extreme risk protection orders may be issued in appropriate situations to reduce the risk of firearms related death or injury. In other words, they want everybody to know how to go about red flagging somebody. So then any jackass on social media could start making phone calls and red flag you. And I keep using social media for an example because a lot of our activity is captured on social media. We post stuff. Sometimes we don't completely think out what we post. And when you take a lot of the things that we say or do on social media out of context, you could use some very mild statements to make someone seem like they're an absolute dangerous lunatic. Application. An eligible entity desiring a grant under this section shall submit to the Attorney General an application at such time, in such manner, and containing or accompanied by such information as the Attorney General may reasonably require. Incentives. For each fiscal year, 21 through 25, the Attorney General shall give affirmative preference in awarding any discretionary grant award by the Bureau of Justice Assistance to a state or Indian tribe that has enacted legislation described in 203. Yeah, let's pay these states and tribes and governments to strip you of your rights. That way, us federal government don't have to come down here and deal with you boys. Authorization of Appropriations. They're authorized to be appropriated such sums as are necessary to carry out this section. In other words, that is a blank check. Money that they are removing from you through taxation, they are then going to use to strip you of your constitutional rights without due process. Seems fair to me. And if you didn't realize that was sarcastic, you need serious mental help. All right, National Extreme Risk Protection Order Law. Requirements, legislation, because remember, states are the ones that are going to have to actually get the legislation nailed down, and then they get grants from the federal government to actually enact that legislation or put the tires on the road and actually do this shit. Requirements, legislation described in this section, or in this legislation that establishes requirements that are substantially similar to the following. Application for extreme risk protection order, a petitioner, including a law enforcement officer, may submit an application to a state or tribal court on a form designed by the court or state or tribal agency that describes the facts and circumstances justifying an extreme risk protection order be issued against the named individual. Is signed by the applicant under oath. And if they lie on these forms, you seriously think they're going to get prosecuted for it? The individual named in the application for an extreme risk protection order is described in paragraph 1 shall be given written notice of the application. In other words, they are going to send you a letter telling you you need to give your guns up and we will be coming to collect them shortly. That's when you will know this is happening. An opportunity to be heard on the matter in accordance with this section, and an opportunity to voluntarily surrender any firearms in the possession of that individual. Notice it didn't say right then that you had to be granted a hearing within such time. That's because when we get into the rest of this, you're not actually going to be granted a hearing. Have fun. Issuance of extreme protection orders. Hearing. In general, upon receipt of an application described in subparagraph 1 or request of an individual named in the application, the court shall order a hearing to be held not later than 30 days after the date of such application or request. Now, yes, that is talking about a hearing. Wait one. After a hearing described in Clause I, if the court finds by preponderance of evidence. Now, preponderance of evidence is one of the lowest burdens of proof in our court system. So let that stick in your craw a little bit. Preponderance of evidence. In other words, they just have to show a lot of evidence. They don't really have to prove anything. Evidence of isn't necessarily proof of. Preponderance of evidence that the respondent poses a danger of causing himself or herself or harm to another individual by having access to a firearm, the court may issue an extreme risk protection order. Length of extreme risk protection orders. An extreme risk protection order shall be in effect until, and this is where you realize these could go on forever. An order is entered terminating or suspending the extreme risk protection order. So they don't even have to write a time on this extreme risk protection order. They can just do a blanket one. And then you would have to wait for another order to be issued to basically shut down that red flag. Or the date, if any, specified in the extreme risk protection order. So see, the date, if any. In other words, they don't have to put a date on there. After a hearing conducted under this paragraph, if the court finds a respondent does not pose a substantial risk of personal injury to himself or herself to another individual by having access to firearms, the court shall order that each firearm surrendered, transferred, or removed under paragraph 5 shall be returned to the respondent. Now, are they going to run a background check on you when they return your firearms? Because if so, you are still a prohibited possessor at this point. Ex parte extreme risk protection orders. Ex parte meaning you are not present. This gets put on you and you don't know about it until it's done. In general, upon receipt of an application described in paragraph 1, the court may issue an extreme risk protection order before conducting the hearing required under this paragraph. Now, this is before the hearing. The application for an extreme risk protection order alleges that the respondent poses a danger of causing harm to himself, herself, or others in the near future by having access to a firearm, and the court finds there is reasonable cause to believe that the respondent poses a danger of causing harm to himself, herself, or others by having in the near future by having firearms. Length of ex parte orders. An ex parte extreme risk protection order shall be in effect for a period of not to exceed 30 days, unless, and there's more, continued for good cause. Surrender and removal of firearms. In general, upon receipt of notice under paragraph 1, the individual is subject to the extreme risk protection order application shall surrender to law enforcement agency or transfer to a third party. Now remember, if you transfer to another party, you've got to go through background checks and jump through all those hoops. All firearms in the possession of the individual. Removal. If an individual described in subparagraph A does not surrender or transfer all firearms in possession of the individual, the firearms shall be removed by a law enforcement officer with appropriate jurisdiction. They come and get your shit if you tell them to get bent. And they will put handcuffs on you when they come do that. Storage of removed firearms. All firearms removed or surrendered to a law enforcement officer under the paragraph shall be returned by the law enforcement officer or appropriate law enforcement agency until the named individual regains his or her eligibility to possess firearms, except that the legislation may authorize a law enforcement agency to contract with a manufacturer, dealer, or importer licensed under this code to store the firearms for you. Transfer the firearms upon proof the named individual will no longer have access to a firearm. So if they say, we're keeping these orders up against you and we don't think you should have firearms anymore, well, the law enforcement agencies can simply transfer these over, sell them, destroy them. Yeah. Notification. In general, a state or tribal court that issues an extreme risk protection order shall notify the Department of Justice or comparable state agency as applicable of the order as soon as practicable. Such notice shall be submitted in an electronic format in a manner prescribed by the Department of Justice or comparable state or tribal agency. Updating the database. As soon as practicable after receiving notification under subparagraph A, the Department of Justice or comparable state agency shall ensure the extreme risk protection order is reflected in the National Instant Criminal Background Check System. You will go in as a prohibited possessor as soon as you get a order placed against you. You haven't been convicted of anything. You haven't been arrested. At this point, you haven't even had a hearing. You go in as a prohibited possessor. Good luck getting out. Confidentiality protections. All personally identifiable information provided to the court, Department of Justice, and comparable state or tribal agencies shall be kept confidential as required by laws of the jurisdiction, except as necessary to carry out the legislation. Additional authorities. Legislation described in this section may provide procedures for termination of an extreme risk protection order, provide procedures for renewal of an extreme risk protection order, establish burdens of proof for issuance of orders described in paragraphs 3 and 4 of subsection A that are higher than the burdens of proof required under those paragraphs. So a state could set a higher burden of proof, but I guarantee you they're going to leave it at the preponderance of evidence. Limit the individuals who may be subject to an application described in section A1, provided that at a minimum, law enforcement officers are authorized to do so, and include other authorization or requirements that the state or any of its tribes determines is appropriate. Now this gets into 922 again. Let's see, 922. inserting paragraph 9. So I think that was... and inserting yada yada after paragraph 9 the following. I'm not on it, but we're just going to read through this because this is just more insanity. This is about prohibitions on you owning a firearm. Is subject to a court order that prohibits such person from having under his or her custody, control, owning, purchasing, or receiving any firearms, or requires the surrender or removal of firearms from the person, provided that the order is issued in a manner consistent with the due process rights of the person. How is having your constitutional rights taken when you haven't even been to court due process? It's issued in a manner consistent with the due process. Okay. Is based on a finding that the person poses a danger of causing harm to himself, herself, or others by having access to a firearm. And in subsection G in paragraphs 8 CII, striking at the end in paragraph 9, I'm inserting paragraph 10, is subject to a court order that prohibits such person from having, owning, custody, all that stuff we just read again, is issued in a manner consistent with the due process, is based on a finding the person is a danger to himself, herself, or others, and conforming amendments. Conforming amendments, Section 31 of the Nix Improvement Amendments Act of 2007 is amended by striking Section 922.8G and inserting paragraph 8 or 10 of subsection 922G. So that's the other two paragraphs that they just put in, making you a prohibited possessor. All right. Now, there was something, and I must have breezed over it. There's something in here when I was talking about hearings, and I skipped over it, where it said you have to apply for a hearing once you get a red flag law put on you. It's simply not given to you. You actually have to make an application for it. It's in my notes here. I just breezed over it up here. So, yeah, you would have to apply for the hearing. And I'm sorry, I'm not going to put you guys through the pain of running back up there and hitting that one line. Firearm safety requirements. Section 922, 18 United States Code, is amended by Section 102, or Section 102 is amended by adding at the end the following. Good God, let's see. That's all. Okay, so that was the original transfer stuff. That was paragraph AA. So we're on, what was this one? This was CC, right? That's BB. CC. Okay, it shall be unlawful for a person to fail to provide notice to an appropriate state or local law enforcement agency of a firearm of the individual other than an antique firearm that was lost or stolen within 48 hours after the person discovers the loss or theft or is informed by another person with knowledge of the loss or theft. So, like, people aren't going to report lost or stolen firearms in the first damn place. Now, a lost firearm could simply be I misplaced a firearm. Maybe I stuck it in a different part of the gun cabinet and just couldn't see it and stuff like that. I'm sorry. This is getting to be such a headache. It definitely is what it is. I'll put it that way. Okay, except as provided in subparagraph 3, a person in good faith reports the loss or theft of a firearm under this subsection shall not be liable for any acts or omissions that result from the theft or loss of the firearm. So what they're saying here is if you play nice and do things like they tell you, then you may not be responsible for any acts committed with that firearm. Yes, you will be responsible for the acts that someone commits with a stolen firearm. Doesn't matter that they stole it. You are going to hold some responsibility for that.
Hey, Dad, can I have some crackers, please?
Go.
But Dad, can I have some crackers?
Can what?
Can I have some crackers?
Monkey, give me a minute and I'll try to get you some. Alright, let me get back down here. So, except as provided, okay, shall not be liable. Now, this shall not apply to a person who knowingly falsely reports a loss or theft under this subsection, or, get this, stored the firearm in a reckless or negligent manner. Kiddo's running in. So, if you don't store the gun in a way that they see fit, quit, Mom. So, if you don't store the firearm in the way that they see fit, then you are going to be liable for whatever happens with that firearm. Now, think about this. Gun-free zones. I have to do something in a government building. I take my firearm off. I leave it in my vehicle. Vehicle gets broken into. Gets stolen. Well, then these people will say you didn't store your firearm in a manner that was approved by your rulers. What, kiddo? I got my son running around and my daughter. So let's get back to this over here. Alright, this goes into effect 180 days after the passage of this bill. Boy, you're not even supposed to be in here because I'm smoking. Right. You getting heavy. Alright. Come on, you can help me. Where you, oh. Let's see. Where were we at? Let's see. Date of enactment. In general, each state, local law enforcement agency shall report to the National Criminal Incident Information Center lost or stolen firearms to the agency under this subsection 922CC. Give me that, which is what we just went over. You're killing me. Okay. Let's see. Use of requirements. Omnibus crime bill is amended by adding at the end. 7. An assurance that for each fiscal year covered by an application that will use not less than 5% of the total grant award for the fiscal year to study, implement effective management and collection of data relating to lost or stolen firearms, reported to the law enforcement agency of the applicant under Section 922CC, 18 United States Code, unless the applicant has ensured the Attorney General has certified that the applicant and each local law enforcement agency of the applicant in substantial compliance with the reporting requirement of Section 301 of the Virginia Plan to Reduce Gun Violence. Dear God, these people are insane. And it keeps going. Please, please make the bad man stop. Offense under Section 922Z. United States Code is amended by adding at the end the following. Minors. and I'm not going to flip to the code anymore. This is just getting too painful. Minors, in general, it shall be unlawful for a person to recklessly leave a loaded and unsecured firearm which has moved in or that has otherwise affected interstate or foreign commerce. I knew you guys were waiting on that line. It's not my fault they put it so far back in the bill. You knew it was coming. Some of you were probably thinking, man, they haven't mentioned it yet. Nope, they're getting to it. They basically took a few different bills and stuck them in this bill. This is all they did. It's all retreads. In other words, it's all stuff that's been submitted before. They just took them, stuck them in this bill. Interstate or foreign commerce in such a manner as to endanger the life or limb of any other person who is under the age of 14. Now, if you guys hadn't seen it way back in some of my videos, I covered a couple instances where very young kids were able to grab a firearm and stop a home intruder. Yeah. Okay. Exception, subparagraph A, shall not apply to a person if the person keeps the firearm secure using a secure gun storage or safety device, or in a location which a reasonable person would believe to be secure, and they are going to determine that reasonableness, or carries the firearm on his or her person, or within such close proximity thereto that the person can readily retrieve the firearm, as if the person carried the firearm on his or her own person. Penalties. This is 924. Is amended in 301 in sections 1 by inserting Q or R, which is that crap we just read up there, and by adding at the end the following. R, a person who violates section 922Z4 shall be imprisoned for not more than 1 year, fined not more than $200 or $2,500, or both. And actually, I think they screwed their number. Well, no, they got it. So if they find that you don't have your guns stored like they think you should have them stored, yeah, you get to go to jail for a year, and they fine you $2,500. Effective date, 180 days after the enactment of this act. Now, they get into section 921. 921, of course, is the definitions. We've been there plenty of times throughout this entire adventure. And they are defining stalking, the term intimate partner, and inserting the following. Means with respect to a person, the spouse of the person, former spouse of the person, an individual who is a parent of a child of the person, an individual who cohabitates or has cohabitated with the person, and includes a dating partner, former dating partner. They might as well add in here roommate of your second cousin's uncle's brother's whatever. Or any person similarly situated to a spouse who is protected by the domestic or family violence laws of the state or tribal jurisdiction in which the injury occurred or where the victim resides. We'll get into it a little bit more, but yeah, this is just another way that they can make you a prohibited possessor. Ever have an argument with an ex? We're getting to it. In paragraph 33A, clause I, by inserting after federal, state the following, municipal, and in clause II by inserting dating partner after spouse each time it appears. By redesignating paragraphs 34 and 35 as 35 and 36, and inserting this new paragraph 34. The term misdemeanor crime of stalking. Now, again, this could be a whole social media thing again. Means an offense that is a misdemeanor crime of stalking under federal, state, tribal, or municipal laws, and is a course of harassment, intimidation, or surveillance. So, harassment, intimidation. So, there have been plenty of times where people have been on social media and basically reply to someone constantly on social media telling them they're a dumbass. Well, yeah, that could get you a stalking charge and make you a prohibited possessor. In a course of harassment, intimidation, or surveillance of another person that places a person in reasonable fear of mental harm or material harm to the health or safety of that person, an immediate family member of that person, a household member of that person, or a spouse or intimate partner of that person. Causes, attempts to cause, or would reasonably be expected to cause emotional distress to a person described in item A, B, B, C, C, or D, D. Expected to cause emotional distress. That is a very wide open category, kids. Especially with people these days. A person shall not be considered to have been convicted of such an offense for purposes of this chapter unless the person was represented by counsel in the case. In the case of a prosecution for an offense described in this paragraph, for which a person was entitled to a jury trial in the jurisdiction in which the case was tried. Either the case was tried by a jury or the person knowingly and intelligently waived right to have the case tried by a jury or pled guilty. So yes, this could be a simple harassment deal, and yeah, they're going to take all your firearms rights away. Person shall not be considered to have been convicted of such an offense for the purposes of this chapter if the conviction has been expunged or set aside, or it's an offense for which the person has been pardoned or civil rights have been restored. If the law of the applicable jurisdiction provides for the loss of civil rights under such an offense, unless the pardon, expungement, restoration of civil rights expressly provides for the person that the person may not ship, transport, or possess or receive firearms. Prohibiting stalkers and individuals subject to court order from possessing a firearm. Again, we're back to 922 unlawful acts. In section D, in paragraph 8, by striking that restrains such person and all that follows, and inserting described in subsection G8, which is all that crap up there. By striking the or at the end of paragraph, in paragraph 10, by striking the period at the end, inserting or, and by inserting after paragraph 10 the following. This would be unlawful acts or unlawful for you to have firearms. Who has been convicted in any court of a misdemeanor crime of stalking, and in subparagraph G, by amending paragraph 8 to read as follows, who is subject to a court order. So this again would be your red flag or restraining order. All this stuff is just so freaking idiotic. That was issued after a hearing in which the person received actual notice and at which such person had an opportunity to participate, or in the case of an ex parte order, relative to notice and opportunity to be heard are provided. So again, getting to this, notice and an opportunity to be heard. within the within the time required by state, local, territory law. In any event within a reasonable time after the order is issued, sufficient to protect the due process rights of the person that restrains such person from harassing, stalking, threatening an intimate partner of such child, intimate partner, or person, or engaging in other conduct that would place an intimate partner in reasonable fear of bodily injury to the partner or the child, intimidating or dissuading a witness from testifying in court. And that includes a finding that such person represents a credible threat to the physical safety of such individual described in subparagraph B. By its terms, explicitly prohibits the use, attempted use, threatened use of physical force against such an individual described in subparagraph B that would reasonably be expected to cause bodily harm. So you could just say something stupid and be covered under this. In paragraph 9 by striking or at the end, in paragraph 10 by striking the comma at the end, and by inserting after 10 the following: who has been convicted in any court of a misdemeanor crime of stalking. All that is prohibited possessors. Red flags. I don't know how you guys do it. Watching this? Trust me, it's no more fun sitting here reading this crap and actually researching it and then changing stuff in the bills. Yeah. I think that's the end. Please, God, make it stop. Okay, yeah, that's the end of this one. Oh, man. So that's enough pain for right now, kids. All you perps, be cool, take it easy. I'm out.